Case number 113888, State of Kansas v. Lawrence Hubbard.
Good morning. If it please the court, I'd like to reserve 5 minutes for rebuttal. My
Counsel, let's give opposing counsel a chance to take their seat. There's still some traffic going on over there.
I'm too eager. Sorry.
It's all right. All right, counsel, you may proceed. Thank you.
My name is Jim Rumsey. I'm a lawyer in Lawrence. I'm the appointed counsel for Mr. Hubbard, both at the trial and the appellate level.
Counsel, I didn't hear, were you asking to reserve some time?
5 minutes,
Okay,
yes.
thank you.
I did at the beginning.
5 minutes is granted.
Thank you. This is a direct appeal from the district court, which denied a motion to suppress the search of my client's apartment. The issue was reserved for appeal, and we stipulated the facts at the trial, and he was convicted of possessing marijuana. The Court of Appeals decision was on the 22nd of April 2016, and it denied our appeal. I filed a petition for review at the request of Mr. Hubbard on the 10th of May 2016, and this court granted the petition on the 28th of August 2017. This search occurred because a police officer was standing anywhere from 10 to 30 feet away from the front door of my client's apartment when he exited the apartment, opened the door, and then shut it quickly. And came up.
Actually, she testified she was 2 feet away.
I understand she testified she was 2 feet away. His testimony was different.
Well, I understand, but she testified she was 2 feet away, and she was the one that did the affidavit for the search warrant, right?
I believe that in cross-examination she conceded that she could have been farther away. In any event, he opens the door quickly and starts talking to her about what she wanted. She had been following him because she thought he was a wanted person on a Lawrence Municipal Court warrant. It turns out by the time that she got to the parking lot and he had exited his car, she confronted his passenger, who claimed that he was not the person wanted, and in fact she had confirmed in her own mind because he didn't look like the fugitive. At that point, another officer had shown up, and both of them claimed that they smelled the powerful and overwhelming odor of raw marijuana coming from the apartment. At that point, they decided to clear everybody out of the apartment, and everybody did in an orderly fashion, and they decided that they would go in and search to make sure that there wasn't somebody inside discarding drugs.
Counsel, how did the officers know that everyone had left?
Well, they stood there, and as they could see inside, people left in an orderly fashion. One would assume that that was enough to give any reasonable person the ability to know.
And those exiting guests were not searched?
They were not searched. No, sir.
Was there any testimony as to whether an observation was made as to whether those exiting people carried any odor of raw marijuana with them?
As I recall, the testimony was that they did not smell them, if you will.
Okay.
But when they got inside to make this sweep of the apartment, they looked in places. I mean, didn't find anybody dumping drugs down a toilet or a sink. And the only marijuana that they were able to observe was burnt marijuana ash in various places. No raw marijuana was found. They then applied for a search warrant.
Okay, no raw on
Nope.
the first sweep.
That's correct.
There was some talk about there was some on a cigarillo or some
Maybe a few
they-
flakes.
But they didn't observe that on the first sweep?
No,
Okay.
not until they went to the ashtray or wherever the cigar butt was.
And the police officer consistently described the odor that was detected as raw and not burnt.
Raw versus burnt, yes ma'am. And as I pointed out in my briefs, that's usually used by officers to try to make the case more significant than it ordinarily would be, because the idea of being raw marijuana is that there's marijuana for sale as opposed to people just using it recreationally.
But
Yes, ma'am.
ultimately, the amount of marijuana that was found in the safe once it was pried open was an ounce or so?
At that, yes ma'am.
Okay, thank you.
And so they got a search warrant. Oh, I'm
Okay,
sorry.
it was 25.07 grams. So
Yeah, and I think 1 ounce is like 26 grams, so
Yeah.
not quite an ounce.
Right.
So they got the search warrant, and they searched throughout the house, and eventually came from the living room and searched all the other rooms. My client's bedroom was searched, and on the closet, there's a shelf with a lock safe. Inside that lock safe, after they pried it open, they found a Tupperware bowl with the 25 grams of raw marijuana. The first thing is suggested is that how anyone could smell that from
Did that
that
bowl
distance
have
is-
a lid, the Tupperware?
it was
bowl?
a sealed lid Tupperware bowl. The distance, even if it was 2 feet to his bedroom, and that closet was at least 30 to 35 feet. Now, I understand that that was a police officer, but I would suggest that no reasonable person could do that. The issue in this case, amongst other things, was there a probable cause? But more importantly, that probable cause was based upon the officer's opinion. That based upon her extensive training and experience, that she could smell the marijuana, and in her opinion, it was raw marijuana. The trial court claimed that this was just a fact expressed by her. In the brief that the state filed, they conceded, well, this was an opinion. And as I've been suggesting, this in fact is an expert's opinion based upon the definition of KSA 60-456A, subparagraph 3, because it defines an expert's opinion kind of in the reverse order. If the opinion is not based on scientific, technical, or other specialized knowledge, then it's a lay opinion. If it is based, it's an expert opinion. We requested that a Daubert hearing be held, and of course the court denied that, and we believe that she was in fact testifying as an expert.
Couldn't a experienced, trained law enforcement officer, especially if they're assigned to a drug unit, adequately describe or indicate what the odor of marijuana is, or
Well,
based upon a specialized kind of experience and exposure?
You know, that's the issue in this case. One of the things that 6456 is attempting to do is to bring Kansas into line with the federal court system and many, many state courts, that junk science and junk expert opinions are no longer available. There are lots of things that may or may not be adequate, because look at the training. If somebody burns something and says, well, here's the odor of burnt marijuana, you don't have any way of testing it from something else. And I did cite the research from the Taste and Smell laboratory at the University of Pennsylvania Medical School, and it tends to suggest that people don't necessarily do it. The problem is that they don't have any controlled things to burn and smell, and that's the purpose of finding out whether or not this is scientifically adequate. I mean, it isn't a lay opinion. And those that think that it's a lay opinion, I would submit, are ones who are giving credibility to an officer because they are an officer. And we shouldn't do that.
So you're basically saying it's not common knowledge what raw marijuana smells like? I think we have some cases that say a layperson can testify they observed a strong odor of alcohol, that's common enough that a layperson wouldn't have to have special training on smelling that, but what about the raw marijuana?
Well, that's why there's the research article that I talk about. It's a myth that people can accurately detect that odor. I mean, human beings don't have a special olfactory system like, say, dogs. They have what humans have. And quite frankly, it's time for us to, and in every one of these cases, the officer is always asked, now, do you have any specialized training in the detection of this odor? Then why do you ask those questions if not to give credence to their opinion? And quite frankly, we're into the junk science, junk expert opinion situation. Now, I realize this isn't the biggest case in the world, but the principles are important. And when the legislature made that change in our evidence to bring in essentially the Daubert standard, it's supposed to be used. If she has the ability to prove that her opinion is scientifically reliable because of the techniques and training and methods that she's used, so be it. This is going to be on a case-by-case basis, and we're a little bit behind in the rest of the federal court system and other states because they've had many, many years to deal with the Daubert standard, but we haven't.
Counsel, can you assume with me that we disagree with you,
Okay.
just for argument's
Sure.
sake, and that we say, yes, this officer was trained and this is not junk science, she smelled raw marijuana? Can you take us through the rest of your analysis given that presumption?
Sure. So from 30 feet away, we are supposed to believe that she could smell raw marijuana when everything that a human being could do to prevent it from being smelled had been taken, except for somebody taking duct tape or some other tape around the container. Where did the odor come from? It may very well be that they smelled burnt marijuana, but they said raw marijuana, not just once, but consistently, and it was overwhelming.
Can I take you a different direction? You're
Sure.
running out of time here. We had the Court of Appeals said first the protective sweep wasn't authorized, but they were authorized. The three officers were authorized to go in and determine if there's anyone that was still there to destroy evidence under the 8-inch high bed or wherever. But if we disagree with that being permitted, what does that do to the search warrant? Because you don't have the affidavit.
Means the search should have been suppressed. I mean, the problem is there was no evidence that this was a drug house, that there were large quantities of drug sales being made.
But we still have, you don't dispute that the officer would have put before the neutral magistrate, I smell raw marijuana.
And did.
Yeah.
And
does that, so does that warrant attenuate the Fourth Amendment violation, if we find it, for the initial entry?
yes,
So then you don't have an argument if the search warrant cured the initial Fourth Amendment violation. Is that what you're saying? You're
the
admitting?
problem of it is that the first entry was for more than, they didn't just, looking in an ashtray isn't going to look at whether or not somebody's destroying drugs. I mean, you might be looking under the bed to see if someone is hiding in there to destroy drugs.
Well, I understand about not credible. I'm trying to get down to the legal aspects, as the chief says. Assume with us, if you will. Assume that we find that the three officers that went inside and made all of those observations of burnt marijuana and that sort of thing, were doing so in violation of the Fourth Amendment.
Yes,
And then they go to a detached, neutral magistrate and get a search warrant.
But that,
Did that warrant cure the Fourth Amendment violation, or was that a product of the violation and has to be suppressed?
it was a product of the first act, and in addition to that, the officer didn't say in the affidavit, and no, by the way, as we were glancing
But
around.
we don't know what was said in the affidavit. That's not in the record, right? I mean, that's our problem. If we had the affidavit that says it included burnt marijuana in the ashtrays, then we could say that was obtained unlawfully, ergo, the warrant was obtained unlawfully, but we can't do that.
Well, officers attempting to cure a Fourth Amendment violation that first occurs seems to me to be pretty offensive to the protection that the Fourth Amendment and the 15th article of our Constitution in the Bill of Rights is assent to do. They shouldn't have been there in the first place, and anything that they do as a result of that doesn't amount to probable cause. And we get to the issue of how far away was the marijuana that this officer smelled. And when you know what the facts were, how can you say that any human being could do that? It is not credible. Could I have 3 minutes to rebut at least the state? Since
I'll give you 60 seconds to wrap up.
Well, I mean, may I have some rebuttal times?
I thought you'd reserved 5 minutes.
I had. Do I still have that?
Yes, you did.
Oh, I'm sorry. Pardon.
No, if you need 60 seconds to wrap up here, I'll grant you that time. It will not be deducted from your 5 minutes.
All right.
I just want to make sure we're all clear on what your position is.
Common sense needs to start creeping into these kinds of situations, and when someone says something so incredible and gets a search warrant or decides that they have probable cause to enter in the first place, we don't have any way of justifying or testing whether or not the officer was being accurate or not, but she said something that is incredible that no human being could do. I think that's important.
Thank you, counsel.
May it please the court, the state of Kansas appellee appears by Kate Duncan Butler, Assistant District Attorney. And this morning, the state would ask that this court affirm the Court of Appeals decision, which affirmed the district court.
And affirm their finding that it was not a protective sweep.
Yes, we did not cross petition for review. The Court of Appeals, it would be affirming the sweep was to protect against the destruction of
And
evidence.
so we would have to find that the police had probable cause through the smell of raw marijuana, and they had a legitimate concern about the destruction so as to permit them a warrantless search for people remaining.
Yes, Your Honor.
And what was the indication that there might have been people remaining?
The testimony of the two officers is that there were several people inside the apartment. Each officer had a different estimate. I believe one said 5 to 7 other individuals. The other said closer to 15.
I understand that. My question is that they ordered everyone to leave, and everyone left in an orderly manner, and they could, with the door open, they could tell no one was in the front area. And so and I don't know, did they make inquiry as to whether anyone was left, or were there any residents of, obviously the defendant who lived there wasn't there, but was there any evidence that any of the residents were there? And why would the officers legitimately believe that a party guest would stay behind with armed officers, numerous armed officers outside, in disobeyance of the order to leave and be hiding in the back room?
There's a few facts that I think lend credence to why the officers had the belief they did. They said the people in the apartment were moving around. Just because people were no longer in the front area, the officers, I believe, testified, or if not the officers, Mr. Hubbard testified, there were areas that were not easily viewed from the front, bedrooms and such. I know that Mr. Hubbard had a roommate. They talked about him coming out. I don't know if there were other residents. I don't know if that information was known. Additionally, there's testimony at the suppression hearing that when Mr. Hubbard, he describes it as power walked into the apartment, he told his guests, hey, there are officers here. And even the officers did observe Mr. Hubbard entering, well, the officer that was there at the time, there was only one then, entering the apartment and then coming back out. And so this is not a situation where Mr. Hubbard, who is already outside, or even the, let's say, 5 people the officers could readily observe through the blinds, all exited. The officers had no way of knowing who could remain in the apartment, who might have been in other rooms not visible from the outside. And it's important to note that Mr. Hubbard closed the blinds, thus obscuring the officer's view, which I think also leads to the belief that there could be someone trying to destroy or otherwise conceal this evidence.
That was overwhelmingly observed when the door opened.
Yes.
And so it was reasonable to believe that that was back in the back of the apartment.
It was reasonable to believe that there was the potential that someone had taken the
Taken
source
it
of
back
this
there.
odor.
I think I read in your Court of Appeals brief that you answered defendant's claim that it was unreasonable to give credibility to the statement there was an overwhelming odor because there were many guests that left that were not searched, and maybe the marijuana left. Is that what you said?
I believe so, yes.
Well, then that leads me to say or wonder, why is it reasonable to believe that there was probable cause to believe that the marijuana was still there?
I believe that that is one of many explanations for why the only raw marijuana,
But you understand
found.
what I'm saying?
Yes.
Is they're saying that they smelled the strong odor, so that gave them probable cause to believe the odor was there, but then all of the occupants left, and they very well may have carried it out with them. And so why didn't that destroy your probable cause? Because we use the totality of the circumstances to determine the reasonableness of the belief. And when there was none observed in the outer room, it's reasonable to believe it wouldn't have been overpowering if it had been someplace else. And if they did leave the possibility that it walked out the front door, why did they get to go in and search?
Well, I believe that argument for it might have left, the marijuana might have gone out with the guests, is one of the explanations for the sort of hindsight that Mr. Hubbard is relying on. A lot of Mr. Hubbard's argument ends in the place of, well, the only raw marijuana eventually found was in a safe, in a closed Tupperware container. How in the world could anyone smell this? The fact remains that it is not certain at the time it was initially smelled where the marijuana was located in the apartment. It could have been on guests who left. It could have also been destroyed sometime in the interim between Mr. Hubbard arriving and the officers doing their walkthrough. There are a myriad of unknowns in this case.
And then how long, do we have any evidence as to how long the odor of raw marijuana remains? If he power walked in and destroyed the marijuana and then walked back out and the smell was overwhelming, that indicates to me that you're arguing there's a possibility that the odor remains even after the product has been removed. And if that's the case, then how credible is the smell of raw marijuana when we don't know how long it lingers?
I do not know if there's any evidence in the record as to how long the smell of raw marijuana remains. I personally don't have a lot of experience in that area. I don't know how potent it is when it is a room away versus 3 rooms away. Those are unknowns that are not answered in this case. What we do have is 2 officers very familiar with the smell of marijuana testify using words such as overwhelming and potent and very strong, that when the door opened and the door closed, they could smell the scent of
The
marijuana.
first officer who was there initially, when did the second officer arrive? At what point in the proceedings?
I do not recall. It was before the walkthrough of the
And
apartment.
before they cleared everybody out,
Yes.
right? 'Cause that decision to clear everybody out didn't happen until after other officers had arrived.
I believe that is
Some
correct.
period of time there. Was there any testimony by the officer, the initial officer who did the affidavit, about the difference between the smell of raw marijuana versus burnt marijuana?
Not very detailed testimony. I think both she and the other officer testified that they had smelled both, and each in their testimony are able to differentiate between the number of times, especially Officer Nicholson, the officer who created the affidavit, the number of times they have smelled each, which would suggest there is a difference.
How about whether the ability to detect the odor at all is dependent upon the amount?
I do not believe there was testimony to that effect.
Okay, thanks.
Can we get to basically the basis for the warrant was the odor of marijuana. That was pretty much the primary source of the probable cause to get a warrant. Was the strong odor of raw marijuana. And what about just that, the plain smell supplying a basis for a search warrant and expectation of privacy that citizens have in their own home? Would you talk about that a little bit, and should we accept that basis for a search warrant, basically the sole basis?
Well, it's important to note that the search warrant affidavit in this case is not in the record, and so the Court of Appeals didn't really discuss the search warrant because of the failure to designate a record. But that said, the standard for probable cause is that it causes a reasonably prudent person to believe that a crime is being committed and evidence will be found in that location. And marijuana is an illegal substance, and when it is not simply a whiff, but the strong and overpowering odor, yes, there is a sanctity that has been granted residents, and courts again and again say a residence is special, but probable cause is still probable cause. And I believe it's Riley, the Court of Appeals case, that takes McDonald, a decision from this court, and applies it, and that's cited in our brief. I believe it's cited in Mr. Hubbard's brief, but I don't recall. Acknowledges that yes, courts do recognize a certain sanctity to the residents, but that doesn't indicate that there should be a separate probable cause standard when you're looking at a residence. And granted, when you have a location, a place that does not move, and a strong odor of an illicit substance from that stationary place, that should be probable cause. It should be enough that...
But you've just admitted that it could have walked out the door with the guest that exited.
That's one of the many...
It's a stationary place, but it's not stationary material.
Not...
And you have to have probable cause to believe the fruits of the alleged crime will be found in that place at the time the search warrant is executed.
And at that time, there was a belief that there was...
And shouldn't that information have been provided to the neutral magistrate? In other words, yeah, there smelled marijuana, but there were also a bunch of people that were there that left and were not searched. And I guess where I'm getting to is, why do we have to have a bright line rule? That seems dangerous to me on both sides. That the magistrate is there to assess the totality of the circumstances. We always say probable cause is a common sense determination based on the totality of the circumstances. And if the officer's driving down the street with a 50-mile-an-hour tailwind and looks up from the parking lot and sees the door of an apartment opens and says, I smell an overwhelming odor of marijuana. My window happened to be up. You need to have that magistrate be able to throw a flag on that and not just say the smell of marijuana. They look at the totality of the circumstances. Here, that would include the fact that it could be as likely as not that the marijuana that they smelled went out the door because they didn't search any of the people.
Well, first, again, the affidavit not being in the record, I will be honest, because it was not in the record, I did not pull it out to review what is or is not in the affidavit. And we have no way of knowing whether all that information was in front of the magistrate on the current record. Additionally, I think part of the idea of maybe the marijuana walked out of the apartment, for lack of a better word, is really to explain the hindsight of where the marijuana was located. I don't know if that was a concern or a thought at the time the search warrant was executed. Again, they did.
But that goes to reasonableness. Did the officers act reasonably? And the officers did a little more than a sweep. They looked under the bed and that sort of thing without a warrant. They invaded the privacy of that home. 3 officers went through there and swept through and looked under the bed and did all that. And they did that because they had probable cause to believe marijuana was in the house. And they were afraid it was going to be destroyed. Yet they let the people walk out and didn't search those people. So that all goes to the reasonableness of the actions of the officers, doesn't it?
Yes, I believe so, but it also has to consider they let some people walk out. I think on the current showing, it's unclear whether they would have had the ability to search those individuals. That's a question never asked, I don't think, in this case. And just because some people left didn't mean, for all they knew, in the back bedroom, they could not see from the front there was a person destroying marijuana or a pile of marijuana. They had no way of knowing at the time when they entered to do that walkthrough. And to, in hindsight, knowing where the only marijuana was found at a different point, to say, at the time the officers were standing at that doorway with not knowing how many people had left or who could remain or what the situation was in rooms they could not see, to impose that hindsight on the officers, I think takes out of the consideration the fact they had so many unknowns at the time. And we're trying to use hindsight to explain these behaviors, but I don't think that undercuts the reasonableness of they didn't know.
The what if time, what if we disagree and say that the warrantless search initially violated the Fourth Amendment? What effect does that have on us? Does the warrant attenuate the constitutional violation, and if so, why?
I would say the warrant does attenuate the constitutional violation. The district court obviously considered the search warrant and upheld it as valid and supported by probable cause. It is not before this court because of the failure to designate a record. The Court of Appeals did not consider the validity of the search warrant. The search warrant stands, and the search warrant was based on probable cause. And there's nothing in the record to suggest that the search warrant is truly a result of this warrantless walkthrough. The officers could have easily closed the door and said, we're going to get a search warrant. In fact, they warned Mr. Hubbard they were going to get a search warrant. That's why they asked the people to leave. This wasn't a situation where they did a walkthrough and then said, okay, now we're going to get a warrant. They made clear the fact that a warrant was going to be applied for and just wanted to ensure that there wasn't evidence being destroyed or otherwise concealed. I see I'm out of time. If there are no other questions, I would simply ask this court to affirm the Court of Appeals.
Any more questions? Thank you, counsel.
Thank you.
As I was listening to the questions by Justice Johnson and the interchange of Ms. Butler asking about what circumstances, why would you believe that there was somebody there to destroy the evidence? it occurred to me, and I'm sorry I didn't cite this before, but what she engaged in was inference stacking, which has been prohibited by this court in the state of Kansas versus Doyle in 201 Kansas 468, in 1968 Kansas. For instance, if you try to infer that there was someone else in the apartment that was hiding and that they were there is because they had a warrant or because they were trying to destroy the marijuana, you've put two inferences on an inference from the facts that you assume a third inference that not everybody left. And every one of the questions that you asked, she answered by doing that inference on an inference. And Justice Beyer, when you were having an interchange with her, is there a different odor between raw and burnt marijuana? And does the amount of marijuana make a difference? Those are the kinds of things that would have been brought out in a Daubert hearing, which were not. That's significant. Page 11 of the Court of Appeals case, the court said, "We stop short of finding that the odor of marijuana would have provided probable cause for the officers to conduct a detailed search of Hubbard's apartment for illicit drugs, including drawers and containers within the apartment." And we really don't have a case that says that the odor of smell allows those kinds of searches. What's the line of a detailed search? Why would someone search underneath a bed that had a clearance of 8 inches? No human could live under there. This was more than a protective sweep. The officers went further than anyone, if they were authorized to do a protective sweep, should be doing. The business about an inference on an inference, especially since the burden of proof is on the state, is a really important principle because it means that you can't speculate beyond a certain point. And that's what you have to do in this case in order to assume
Quote from
probable
the
cause.
Court of Appeals, does that indicate to you that what that court was saying is that probable cause and exigent circumstances, the probable cause of the smell of marijuana, that level of probable cause, and exigent circumstances, the destruction of evidence, allows for a protective sweep to protect the evidence, but not a full-blown search? Is that what you're kind of understanding they're saying?
Frankly, no, because they didn't mention the phrase exigent circumstances in the quote I just quoted, and they found that there weren't exigent circumstances. There wasn't any reason that an officer couldn't stand in the open door of the apartment and wait for the warrant. No reason in the world.
Well, I thought they said that there could have been someone in the back room that would have destroyed evidence.
And in order to make that assumption, you have to stack inferences on an inference. Number one.
Well, I understand, but my problem is once you get probable cause and exigent circumstances, you get to search. And what I read him saying is, well, if it's based on smell of marijuana, it doesn't give you a full-blown search, it gives you a sweep search. And I don't understand, when we're talking about vehicles, once you get the probable cause and then the exigent circumstances of the mobility of the vehicle, you get to search. You don't get to just kind of look in there, you get to do the full-blown search. So I don't understand about the level of probable cause that the Court of Appeals is.
Well, this is not a vehicle, this is a residence, number
Right.
one. And number two, there weren't any exigent circumstances. How's somebody going to get rid of marijuana? Are you going to say that there was somebody that had something besides marijuana and that they were putting it down the drain? I mean, an officer standing in a small 2-bedroom apartment could hear when a toilet flushed, could hear when the drain, when water was being poured down a drain. The idea that if it was marijuana, how else do you get rid of it? And yet it's not something that you can get rid of easily without making some kind of noise. Problem, I believe, in this case is that all of this hinges upon the officers claimed ability to distinguish between raw and burnt marijuana, and not just some small odor, but an overwhelming odor. How long it lasts, the amount that it has, the difference between the odors are all things that should have come out in a Daubert hearing, which did not happen. And therefore, we believe that there wasn't a basis for them to enter in the first place. And that her claim that she could smell the marijuana had to be further investigated. Magistrate has a job to also inquire, not just accept what's in the affidavit, so that all of the circumstances can be determined. We believe that this matter should be reversed.
Who's got the burden here? If does the state have to, if we were to find that the first warrantless entry was a violation, do you have to prove that the warrant was invalid?
I don't believe so.
Or does the state have to prove it was valid to attenuate?
As I read the statute, it's the burden of the state in a motion to suppress the whole way, and I don't believe it ever shifts to the defendant.
Do you have any further questions? Thank you, counsel.
Thank
You both for your arguments this morning. Court will take this matter under advisement. This time.